and namaskar to all present. Uh, I'm delighted to have you all for the introductory session of the specialized certificate course on the Insolvency and Bankruptcy Code IBC, and welcome all eminent faculties like Dr. M.S. and Nadaji yourself and Dhingra Saab and everyone participating in this particular webinar. I think there are almost 38 total participants till now, maybe joining later on. As at the Institution of Valuers, we take immense pride in our legacy. For over 55 years, we have stood as a pillar of professional excellence, delivering quality services across diverse sectors. As an ISO certified organization, our commitment lies in upholding industry benchmarks and continually strengthening the capabilities of valuers and all related stakeholders. Our specialized certificate courses are the extension of this legacy, designed to offer in depth, future ready learning opportunities that are not only relevant but also widely recognized. These certificates go beyond being a mark of course completion. They serve as a benchmark of professional competence and preparedness in a rapidly evolving landscape. In recent times, IBC has reshaped the financial and legal framework of our country. It has become a cornerstone in how we resolve insolvency, restructured businesses, and recover value in distressed scenarios, whether it is a company undergoing insolvency, assets being liquidated, or resolution plans being negotiated. Valuation is one of the most critical and sensitive elements of the entire process. Recognize this, we designed this course not only for valuers but for lawyers, insolvency professionals, support service providers, students, COC members, and anyone seeking to understand the practical working of IBC in depth and who are attached with the IBC per se. This is not a textbook program, it is a curated learning experience led by a diverse and accomplished panel of experts, including senior registered valuers, legal specialists, experienced resolution professionals, and former regulators. They bring with them a wealth of real world insights, procedural know how, and case based perspective to ensure you walk away with a comprehensive 360-degree understanding of the IBC landscape. Whether you are new to IBC or already working in this domain, this course will help you build domain specific knowledge, strengthen your ability to contribute meaningfully to the resolution process, and stay aligned with regulatory expectations. Thank you again for being with us. We encourage you to engage actively and don't hesitate to ask questions. Let us make this journey meaningful, insightful, and truly enriching together. Thank you again, and I think this particular session with the presence of some eminent personalities amongst us, it will be further enlightening for the participants who have joined us and who would be joining us. And we expect this course to start, I think, and Radhaji will give further details when to join and how to join. And this has been the program has been designed in to suit all and to suit the timings and the availabilities and create IBCs for ease of doing business. So this course, I feel that it will be in on those directions only, ease of learning and going forward for to understand distinctly about the IBC. Thank you all. Thank you very much. Namaskar.
Thank you so much, sir, for the enlightening speech. Now, I would like to request Dr. Sahu, sir, for his opening address, please.
Thank you so much, madam. You started with the question, what is IBC? I think the insolvency is something as old as the commerce itself. You are familiar with Shakespeare's Merchant of Venice, where the character Antonio, a prosperous merchant, borrows money from Shylock, that's a Jewish moneylender, but he pledged a pound of his place as collateral. So when his ships are lost at sea and he can't repay the debt, Shylock demands, give me my bond, give me my pound of place. The court has intervened. Court allowed the Shylock, you please take the place, but you can't shed the blood while you take the place. So this really made a contract unenforceable, and this tells us, this parable kind of thing captures the inherent risks, inherent perils of a credit risk, the how cruel the collateral could be, and the need for equity to temper the rigors of contract. So the insolvency law has since evolved as a structured response to such impasse where strict legal rights clashes with broader economic and social considerations. But who guides the way out of this impasse? It is the insolvency professional, the impartial fiduciary having no interest in the matter but tasked with navigating the path from distress to resolution. And I wanted to emphasize from distress to resolution, it's not that they are associated with only resolution after the impasse has happened. And you may be, those who are familiar with the IBC data would know that about 30,000 stress cases reached the door of NCLT, but before they could be admitted, they were withdrawn, telling that the resolution happens even before admission, and in fact, much before. This 30,000 applications had an underlying default of 10 lakh crores. And that is the number we know which reached the NCLT, but we do not know the number. How many got resolved even before reaching NCLT? So it is important that we recognize the insolvency professionals, even recognize the opportunities before the resolution. That means the resolutions that is happening under the shadow of IBC. In fact, I would quote another author. I used to say this when I was in IBBI. There's an exchange between two characters, Bill and Mike, in a novel called The Sun Also Rises Up against Hemingway. So the dialogue was that, how did you go bankrupt? Two ways, gradually and suddenly. So this tells that the decline happens, the stress happens, often remains unnoticed, silent, slow, until it culminates in abrupt collapse. So that was, of course, the India's Christ, I would say, India's journey with insolvency followed a similar arc. For years, for decades, the financial stress simmered beneath the surface, but firms clung to the life despite eroding viability, while banks continued lending to postpone the inevitable recognition of bad loans. Then almost overnight, these cracks widened into a full-blown crisis, forcing an urgent reforms, and out of that moment of reckoning emerged the insolvency bankruptcy code. But the point I wanted to make is that the opportunities for insolvency professional and the skills required are not only after the deadlock has happened, and it starts much before. And these are this relates to an area which Mr. Goel was talking about, the economic matters. This is actually an economic freedom we call the freedom of exit. We started a long journey sometime in 1991. That decade, we focused on freedom to start business. Next decade, freedom to continue and grow business. And the next decade, we started the journey to have the freedom to exit. So this freedom is a part of an economic freedom which has several shades of gray. It's not black and white like the other laws relating to civil liberty like Indian Penal Code or those kinds of things. Here, every permutation combination is possible if there is a proper understanding of the context. The economic laws generally, in fact, the Supreme Court told in one matter, in I think Swiss grievance matter, that these are the matters of experimentation and we allow these kind of law, evolution of laws. But I wanted to say that in economic laws, what matters is the context, not as much the conduct. What you do is not as much material, but if that context warranted you to do it, then that's a perfectly accepted. So understanding that context requires a much higher ability. And particularly when we are having a law which rewrites the rights of the stakeholders. What does insolvency law do? Company has been doing well. It has several parties. It has entered into contracts with several parties. And one set of parties are who have given the money to the company. There are hundreds of people who have entered into bilateral contract with the company. Company was doing well. Everybody feels secured. It's a huge company, thousands of crores of business. My money is only 5 crore, 10 crore. I will easily get it. But when this kind of the dialogue I refer to, it happens slowly and suddenly when you find that there are not enough assets to meet the claims of all the claimants or all the creditors. So the ones who come first, they will get their dues first. The one who comes next, he may get part of the dues. The one who comes last will not get anything and the company will bleed to death. This is a kind of a negative sum game. But to get out of that, the insolvency law says that now let us forget all your pre-insolvency rights. We will rewrite what are your entitlement, which we call a priority rule or waterfall, familiar with section 53 of the Act. So now all of you are bound, all those who are giving money to company or claimants are bound by this waterfall. And once your rights are overwritten, you had some rights, this insolvency law overrides all those rights. And after insolvency law overrides these rights, we have a new priority rule. That priority rule prevails over every other law. That is section 238 of the IBC. So when we are dealing with the rights of people, and you have seen several matters reaching the Supreme Court because we have not dealt, or it is a matter of view actually, that the way the rights have been dealt are not the appropriate way. That's why matters go to NCLAT, Supreme Court, and many times it has gone starting from SR kind of things. Many times it has reached to Supreme Court. So it is the job of the insolvency professional to safeguard the rights as guaranteed in the law, not as guaranteed in the contracts the parties have signed. So these are the examples that I wanted to tell, that this insolvency law has really professionalized the insolvency resolution. It gave birth to two new regulated professions, insolvency profession and registered valuers profession, and has mobilized also the expertise of other professionals like chartered accountants, lawyers, and company secretaries. In fact, the insolvency professional, the insolvency transaction is a kind of orchestra. So many people have a role: resolution applicant, a debtor, creditor, the promoter, director. Everybody has a role, but the sutradhar to this orchestra, the master of the harmony, whatever that is called, is the insolvency professional. He has to pull all of them together and ensure that they move in sync so that the resolution process completes in a time-bound manner. And there are specialized institutions like the adjudicating authority, IBBI, the information utility. They provide the procedural clarity. They reduce information asymmetry. They enhance transparency. But it is the insolvency professionals who are, I would say, empowered by the vast growing body of jurisprudence. And I think the insolvency jurisprudence is perhaps the largest of its kind in India in recent times. And that is the resource available to insolvency professionals to understand how to run these processes. And we have created a market actually. The insolvency is an outcome of market forces actually. So this law gives primacy to the market mechanism to resolve the stress. The insolvency is an outcome of market forces. So it is only the market comprising the corporate debtor, promoter, creditor, potential resolution applicants. They will find out the most viable solution. It could be resolution plan. It could be the liquidation. In fact, the law really is agnostic about what is the appropriate resolution, and it is left to the market participants. But unfortunately, on several matters of IBC, there's some misunderstanding continues. Like what is the objective of this IBC? It is in this long title. Long title says that it is the law for insolvency resolution of X corporate persons, etc., in a time-bound manner, value maximization. So the time-bound value maximization, promoting entrepreneurship, these are not the objectives. These are the only talks about how you go about it. In the matter of Swiss Re, Supreme Court actually started the confusion, saying that in the long title, nowhere the word liquidation appears, giving an impression that resolution means resolution by a resolution plan. So only what I'm trying to say is that even at the highest level, there is no clarity on several matters, but insolvency professional has to have full clarity while it deals with the matter. And the market, as I told, IBC is completely agnostic. Whether you rescue a company through a resolution plan or close it by liquidation, both serve the same economic purpose, that is the efficient allocation of resources. And choice is left to market participants. So I want this efficient allocation of resources is extremely important. It is because we all have limited resources. We do not want resources to remain idle at any time. So this is the IBC gives the process and entrusts the entire property of the distressed entity at the disposal of the insolvency professional. The day it is admitted to process, insolvency professional replaces the board of directors. So these scarce resources of the country are given in a trust to an insolvency professional to keep, safeguard it, to grow it, to maximize its value, to run the business going concern, and ensure that there is people who are entitled as per their priority rights they get. So these are very complicated cases, but we expect insolvency professional to achieve such great take such great responsibilities. And that is what it requires us, or it is incumbent on us to groom the professionals who can shoulder these kinds of responsibilities. So I compliment IOB, Mr. Goel and his team for taking up this kind of a professionalization program so that the insolvency services get better professionalized. Thank you.
Thank you, sir. Nice of you and to be with us and being, the main key person behind this whole thing. Rather, I would call you father of this IBC process. So it is really enlightening, as well as we are honored that you are with us for this particular course. And I think people will take great advantage with your kind of experience, your knowledge, for the best of the use in the IBC courses. Thank you, sir. Over to Anuradha.
Thank you, sir. The next speaker of the day is Mr. Anil Goel, who is the founder of the AAA Group, AAA Insolvency Professionals LLP, the India's largest IPE under the IBC, and regarded as the country's most experienced resolution professional and liquidator. We welcome you, sir, and would like to hear your perspectives on the role of personal insolvency in the IBC regime.
Thank you very much, Anuradha ji, and congratulations to Vinay Goel ji for starting this specialized certificate course. Because see, I definitely would say whatever Dr. M.S. Sahu has said, That is the real experience, real numbers, and the insolvency professionals or lawyers or even registered valuers, they have, although there is a competition in the market, although there is a presently dearth of cases, but considering the comparative professions, still I would say that the registered valuer, insolvency professionals, lawyers dedicated to insolvency practice are still better. See, saying something, because see, today is not something that we can say that it is a complete session on personal insolvency, but I would say that personal insolvency is also very, very important, because see, the number of cases are very high. The total number of cases so far, in fact, it is more than 1,300 probably, which are already in the NCLT. So presently, personal insolvency is applicable only to a person, an individual, who has given personal guarantee to secure a corporate loan or loan to a corporate entity. Now, the corporate entity, it can be a private limited company, a limited company, or a limited liability partnership. So, in case there is a default and the lender has to invoke the personal guarantee if it is given by the director or any relative or any person who actually is also again added by a collateral security. So all these people are called personal guarantors, and the insolvency law for the time being, as far as the individual insolvency is concerned, that is only and only applicable to personal guarantors. And that too, it was implemented by Government of India, in fact, quickly, because there was a kind of a scenario which was seemingly, as far as the public is concerned, it was seemingly an environment which was coming that the Insolvency and Bankruptcy Code is now, it is taking over the companies from the promoters. The promoters are not managing those companies, but they are still living king-size life. That means they are still living king-size life. That means that they are still living on all these luxurious lifestyle, luxurious cars, luxurious houses. But then those people who had given loan to them, they are suffering. The individuals are not suffering. The promoters are not suffering. Therefore, immediately it was implemented that as far as those people are concerned, who are considered to be the promoters of all those failed companies, they also must face the consequences. Now, how the government thinks that they will face the consequences, the government would like to say that we have made all of them as bankrupt. We have made all of them as bankrupt, so they have no asset. They have no asset, and we have conducted a complete process. So that is what was the main objective of the personal guarantors insolvency, that the government never wanted that somebody could say that although the company is not with them, but then they are still richer. Only the adverse impact is on the workmen, adverse impact is on the suppliers, and also it is to the economy that the company is closed. So the personal insolvency, therefore, it was launched like this, and the Department of the Banking Affairs, Finance, in fact, wrote a communication to all the banks that they should proceed against all the guarantors. That was in somewhere in August 2020, and thereafter, every bank is trying to start insolvency of personal guarantors. See, like broadly, personal guarantor insolvency is two parts. First part is the resolution of the insolvency resolution process. No, we can't say that it is corporate insolvency resolution process, which is CIRP, but we can always say that personal insolvency resolution process. So in short, it is also called PIRP. So the PIRP, so once the application is submitted by the lenders, application is submitted to NCLT. One, that the application can also be signed by the proposed insolvency professional who would be appointed as RP in the case of PIRP. So he will also have to sign. But see, then the NCLT will ask for a report under Section 99 from the proposed IP. Now, the objective of this particular report was that instead the bench or NCLT makes an effort to kind of verify all the facts. So this is again a kind of endeavor that the time of NCLT may be saved, and this report can be taken from the proposed insolvency professional who would become RP. So if the report is submitted, then the PIRP starts. Then the order will be passed by NCLT, the PIRP will start. So this PIRP will continue for 6 months, 180 days, and there is no provision for extension. And the only thing is that there may be exclusion because of any stay, but as far as the extensions are concerned, hardly there is any provision for extension. But within this 180 days, the repayment plan has to be submitted, and repayment plan has to be approved by the creditors. And once the repayment plan is approved, it can be said that yes, all those creditors who participated into PIRP, their complete discharge is available to the personal grantor against those liabilities. But in case the repayment plan is not approved, then a fresh application will be filed either by the personal grantor or by the creditors for commencement of bankruptcy process. In the bankruptcy process, the same insolvency professional would be appointed as bankruptcy trustee in case he is willing to continue as bankruptcy trustee. In short, we can call it as BT. So now we have done in PIRP. First, the PIRP will complete, and then the bankruptcy process will start, and the same IP can be appointed as bankruptcy trustee. Now, the bankruptcy trustee is the same process as we have seen in the liquidation of companies. And in the liquidation of the companies, the liquidator, in this case, BT has the powers to take control and custody of all the assets of the PG, all the businesses of the PG, and he has all the powers to seek information from all the government authorities regarding assets of the PG. He will be able to access to the public information for understanding all the assets owned by the PG. So once all this detail is prepared, then he can sell all those assets, and based on the distribution pattern, he will again distribute to the creditors whatever his recovery is possible. In PIRP, the resolution professional doesn't have any power to take control or custody of the assets of PG, not even the bank account, not even any asset. So during PIRP, there is no power with the RP to take control and custody of the business or assets of the PG. In bankruptcy trustee, in the bankruptcy process, the BT, the bankruptcy trustee, has all the powers to take control and custody on the bank accounts, all the businesses of that person, all the assets, and then he will sell, and then he will also try to find out. He will also, the BT will, bankruptcy trustee, BT will also try to find out the avoidance transactions. So the avoidance transactions are not involved during PIRP. Avoidance transactions, sale, taking control and custody, everything comes in the bankruptcy process, not in the PIRP. PIRP is a simple process where the he will submit the PG will submit a repayment plan, whereas in the bankruptcy trustee, the BT can also go for asset tracing. BT can also fight for some of the claims of that individual, so that if the money is received, that will also be distributed. And the BT will also do avoidance transactions. BT will also find out if there are any other fraudulent transactions. But one which is important, that this law, the individual insolvency law, is not about recovery. I was one of the member of the committee constituted by IBBI for implementation of personal insolvency law in India. So we have gone through all these 5-7 people as the members of the committee. We have gone through, and rather we have helped drafting of the regulations for PIRP and for bankruptcy process. Whenever we used to meet, the main focus was that this law is not about recovery. This law is all about individuals, humans, and the more focus was on humanity rather than recovery. Now, what is humanity into this? Humanity is that this is about a fresh start. Any individual has a right to start afresh in life. It is starting afresh because he already have had his financial death. Now he would again start his financial life. He will again start his social life. So that is the concept of the individual insolvency, where anything which is very personal to life, like basic occupational assets, basic livable house where a human can live. All this is assured. All this is assured to individuals, humans. And the bankruptcy trustee will have no power to take away everything, whatever he finds. Like he has a right for occupation, all his occupational tools, all cannot be snatched from him. He will have to be given a small basic house. In today's introductory session, what I would like to say that this is a very, very broad kind of view of the personal grantor's insolvency. There are details which are much larger, and it cannot be covered in 1 or 2 sessions. There are separate sessions required for PIRP, separate sessions required for bankruptcy trustee, and then we will also include what are the restrictions during bankruptcy process period, what are the assets which are excluded from bankruptcy process. So, and what are the assets which are included? What are the minimum assets that would be retained by the individuals? All this can be discussed later when normal process will start. For the time being, I would say all the best to all the participants who are joining this certificate course. And as I said, either you are an insolvency professional or you want to become an insolvency professional, or you want to practice as a lawyer, or you want to practice as a registered valuer. This course is going to add value in your professional life. This course has been, in fact, Mr. Vinay Goyal and his team, they are working in such manner that this course actually will help you in kind of improving your professional skills. So thank you very much, Vinay Goyalji and Anuradha. This is what I wanted to say in this introductory session. Thank you.
Thank you, Anilji, and a very enlightening one. And the way you have explained, and I think the participants will come to think that this course is going to be really interested. It will not be like other courses, but it is going to be interesting in a way that lot many things, lot many areas where there are gaps, there understanding is not proper. So people like you who have been working since the beginning in this profession, being IPs and other areas, they will make best of the use of this particular course. And thank you, Anilji, for being with us. and for guiding us regarding the course preparations and how to go about the topics and all. So thank you, sir. Thank you.
Thank you. Thank you. Thank you.
Thank you so much, sir, for your insightful speech. Now, I would like to welcome Dr. R.K. Patel. He is a Vice President of Institution of Valuers. Sir is also practicing as an insurance surveyor and loss assessor, valuer, CMA, chartered engineer, and a certified energy auditor. Sir, we would like to hear your views on the interface of different laws under IBC.
Thank you, Anuradha. And the subject is interface of different relevant laws with IBC 2016. As you all know, that IBC interfaces with other laws. There are two objectives, as has been mentioned in IBC 2016, that is consolidate and streamlining the insolvency and bankruptcy proceedings in India. Second is the ensuring a comprehensive legal framework for debt resolution and asset recovery. By virtue of this, IBC overrides certain provisions of other laws and establishing its primacy in insolvency matters. This interaction is crucial for effective resolution of stress assets and promoting ease of doing business. This is the ultimate objective which IBC takes. Now, question is why this interface is important, because there are various laws which are affected because of IBC 2016. The first and foremost is the overriding effect. If you see IBC 2016, Section 238 of IBC grants it an overriding effect over other laws, meaning its provisions take precedence in case of conflict. Means IBC has a I think precedence because IBC will prevail first compared to other laws. But this doesn't mean that other laws are ineffective, because they are to be interfaced in and interpreted in a systematic manner. This ensures the IBC's framework for insolvency and bankruptcy is not undermined by conflicting provisions in other statutes, because other statutes are also conflicting. So this is the overriding effect. That's why there is a definitely call for interface with other laws. Then another is the consolidation of laws. Consolidation means the IBC amended and subsumed provisions with various other laws related to insolvency and debt recovery, such as Companies Act and Recovery of Debt and Bankruptcy Act 1993. So this has consolidated these acts to a single code, that is IBC 2016. This consolidation simplifies the legal landscape and makes the process more efficient. But still, there are a lot of laws which are interpreted in a different way, and that affects the CIRP proceedings as well as liquidity proceedings. Third is the specific interfaces, which has been mentioned in the IBC 2016. One is a Companies Act regarding particularly regarding SIG companies and harmonizing provisions related to insolvency. Third, in the specific interfaces, SEBI regulations. Now, IBC interaction with SEBI regulations, particularly regarding recovery proceedings, has been a subject of legal interpretation, with the IBC generally taking precedence. Now, here there is a conflict. Some of the provisions of SEBI tries to override, whereas IBC is generally taking precedence. I think it becomes generally the court matter. Then tax laws. The IBC also interprets with tax laws. With Section 2038, that is the overriding effect, giving overriding effect. Although there are specific provisions in tax laws, they acknowledge the IBC priority on insolvency matter. So tax laws are also to be interfaced because under tax laws, the assessing officers or this authority is given. The authority has been given under Income Tax Act to take over take the possession of the properties. I think here there is a conflicting situation come. Competition law, another. The IBC and the competition law interface, particularly with the corporate entity, bids to acquire and undergoing insolvency. I think this is what competition law, you know, that it should not result into any kind of monopolistic situation for any of the acquirer of the property under insolvency. Competition law may regulate such combinations. Now there are other laws also like SURFASI, Limitation Act, all are being affected because of IBC, and they need interpretation. So another is the why interface is required is the promoting corporate governance. The IBC emphasizes on time-bound resolution and stakeholders' right has contributed to improved corporate governance practices in India. By holding directors and management accountable and promoting transparency, the IBC fosters a more robust and responsible business environment. There are certain challenges also, and that's why interface is required. Implementing resolution plans under IBC can present challenges, including coordinating with the stakeholders, addressing conflicting legal provisions, and ensuring compliance with various regulatory requirements. Capacity building of regulators and establishing collaborative mechanism between insolvency institutions and regulators are crucial for streamlining the process and promoting ease of doing business. Ultimately, ease of doing business in India is a priority and repeatedly said under with the preamble of IBC. So, IOV-RVF has taken initiative to introduce this course, and in this course in this part of the course of interface of different relevant laws with IBC, IOV-RVF intends to cover few points which are relevant as far as the interfacing of laws are concerned. That is first is the interface with the statutory authorities and enforcement agencies. I think here there are really some kind of complications come. Statutory authorities, one is the taxation, land authorities, provident fund authorities, etc. And enforcement agencies, of course, they are also coming in between. Second is the interface between tax laws and IBC. So interface with mainly with the income tax and the GST laws. Third is the interface between IBC and foreign investment instruments. Fully and compulsorily convertible debentures pose very great problem to most of the IPs. And external commercial borrowings, foreign direct investment, foreign portfolio investment, commercial loans, official flows, all these pose a lot of interfacing problems for the IPs or any of the person who is practicing in this regard. Another is the interface of regulatory bodies with IBC. So regulatory sectors like telecommunication, power, aviation, mining, they themselves different regulations. I think these regulations are also required to be interfaced and how they are interacting with the provisions of IBC 2016 and whether it gives the powers, really powers can be exercised under IBC to have the overriding effect on the regulatory bodies, regulatory requirements of certain sectors like telecommunication, power. The regulatory is also giving some licenses, concessions, and the recovery of regulatory and other dues. I think this is also a great problem for the IPs. Approvals and licenses, transfer of licenses and other approvals. I think these are the key issues which are required to be addressed, and then IOV-RVF has included in their course contents. Interface of IBC and with the Prevention of Money Laundering Act 2002. I think this is another area where it is required to be really interface with the IBC 2016. And in the competition law also, it is to be interfaced. I think these are the areas, and there are certain other rules and regulations where IBC interface is very much required. So this is the intention of including this part in the course, and IOV-RVF has taken lead in introducing this specialized certificate course on IBC, which will be helpful not only to the IPs, not only to the regulators, but also to the other people who are directly or indirectly connected with the insolvency proceedings, like registered valuers or resolution applicants, and so on. So thank you very much for including me in this particular mission. Thank you very much, sir. Thank you.
Thank you, Patel sir. I think your presence as a president, a vice president of IOV, and an eminence, and you have an expertise in all three classes of assets, being a cost accountant as well, and a mechanical engineering background, and real estate.
IP.
People will benefit from your lectures and your experience. We
Thank you. Thank you.
anticipate that. Thank you, Patel sir.
IP as well.
IP as well. Sorry, I missed that. As well as a registered valuer in two classes. Third, you are not attempting, I know very well. But soon I think you will be having all
Yeah.
three classes of assets.
Thank you. Thank you.
Thank you. Thank you, Patel sir.
Thank you.
Thank you, sir, for your insightful speech. Now, we would like to invite Rajiv Dhingra, sir. He's a chartered accountant, insolvency professional, and a registered valuer. He's also practicing as a concurrent and statutory auditor. Sir, we would like to hear from you the role of liquidation in IBC regime, sir. Sir, you are on mute, please.
Yeah, am I audible?
Yes, sir.
Thank you. First of all, my compliments to Vinay sir for this fantastic course. And because I mean, as many of the participants would agree with me, there are many courses being conducted by various authorities and various institutions which lack this kind of faculty and this kind of course coverage. I mean, you talk of the presence of Anil sir, Patel sir, Abhay sir. I mean, all of them are stalwarts in their own fields, with Anuradha man being in the lead for this course as well. So this is fantastic course, and my compliment to the entire IVF team, and I really wish them all success. Now coming to the liquidation part of it. Sorry, Anuradha man, I'll pick some of your CIRP points also into this with your due permission.
Please,
And
sir.
now,
Please.
friends, what happens, as Dr. Sahu and Anil sir also had pointed out to an extent, that whenever any company goes into liquidation, right now personal insolvency is not there. Only personal guarantors insolvency is there. Personal guarantors who are guarantors to a CD, which is already under insolvency process. Against them only this insolvency proceedings under IBC can be continued as on date. Personal insolvency has not been introduced into India. And now what happens is, once a company goes into CIRP, first comes the resolution part of it. That part will be taken care of another man. So I'll not be touching on that aspect in a greater length. So as part of the CIRP, what happens? The COC, Committee of Creditors, they first try to resolve the matter by through RP, and while RP calling for resolution plans for the matter. Now, in case during the CIRP process itself, either there are no assets, or because the COC is of the opinion that the assets which are available, they will not be able to take care of the CIRP expenses itself, or it is not a fit case which asks for revival, because IBC is nothing else but putting a bad or sick company back on tracks revival process. So in case they are of the opinion that it is not a fit case for revival, either the COC of their own, or when the plan is under deliberation at NCLT level, adjudicating authority level, NCLT can of its own also they can state they reject the plan. That can be another angle. Or they say that the plan submitted is not meeting the criteria as prescribed under section 31 of IBC. Then they can refer a particular case to liquidation. Now, that's so various angles. Either it can go into early liquidation because there are not assets. RP puts up a proposal to COC. The assets are not sufficient, or he is not finding it to be a fit case for revival, and COC takes a call, or at the behest of NCLT, or under there can be another option by way of voluntary liquidation. Voluntary liquidation we'll touch upon afterwards. So then this case can be referred to liquidation. Liquidation under section 33 of IBC, and which are governed by regulations prescribed under IBB for liquidations. Now, for under this, what happens is you will the RP will RP in this particular case in CIRP insolvency professional is called resolution professional, that is RP, whereas in liquidation an insolvency professional is called liquidator. So the liquidator will publish uh, uh, advertisement in the newspapers, call for claims. Advertisement has to be there in within 5 days, as against IBC, which is as against CIRP, which is 3 days. Here, it is not collation of claims, but verification of claims. So within 30 days, he asks the claimants to submit their claims, and in next 30 days, he verifies the claim. In CIRP, it is collation of claims. In liquidation, it is verification of claims. And in case someone has not submitted its claim under liquidation, against liquidation application or under liquidation, but his claim was submitted under CIRP and that claim was accepted as well. So in that case, liquidator has to accept those claims as it is, but after due verification, because RP had the obligation of collation of claims, whereas liquidator has the responsibility of verification. So he will verify the claims. After verification, his as against in CIRP, COC is there. Out here, it is SCC, Consultative Committee. SCC. Here it is consultative, stakeholders consultative committee. In liquidation, SCC is there. So under the advice of SCC, COC directs, SCC advises. So under that advice, the entire process will continue in case no claimants are there, no creditors claimants are there. Only stakeholders are there. Stakeholder, who could be a stakeholder in a company? The shareholders are the stakeholders. The equity shareholders are the stakeholders. Fully convertible preference shares, they are the stakeholders. So those stakeholders, they form part of the your SCC. Now the SCC takes that guides the process, and liquidator runs the process per se. And the process has got to be completed in case no creditors are there within 90 days. Normal scenario, the case has to be completed, or in the alternate, within 270 days, the case has got to be completed. In case it is stretching beyond the permitted time under these guidelines, and then in that case, SCC would permit the liquidator to extend the time period, and the liquidator, under intimation to IBBI, they will extend the time period, but on valid grounds. So then the assets would be put on sale through competitive bidding and the liquidation portal, which is there on IBBI side. Those formalities need to be carried out. So the liquidator per se tries to recover whatever best they can, for which they get a fee which is either passed by the COC or as prescribed under IBBI regulations for liquidation. The rates are prescribed therein, or in and in case SCC has passed those liquidator fees or the rate to be paid to the liquidator, then they charge that particular fees as well. So that is how the liquidation process progresses. And on realization, the liquidator, after meeting the liquidation cost, disposes of the payments, the realized amount amongst the SCC and the creditors, whatever to the best possible tune, whatever is possible. So that is the brief scenario on liquidation, and that entire liquidation phenomena or procedure would be dealt threadbare when we get into the class. Though we will try to cover as much as possible, we'll try to touch base on each and every aspect of your liquidation within those 2 hours. We'll take up some important cases as well, and as decided by the core committee taking care of this particular process, I'll be distributing a complete, well-built PPT also on the subject, and that's all for the introductory section on this liquidation part. Thank you.
Thank you, Dhingra sir.
Thank you.
We expect a lot from you, and people will be definitely benefit from your experience as
Right, sir.
IP and
Definitely.
Mr. Value, and your share your
Sir.
bulk of information or bulk of experience with others. Thank you very much,
Sir.
sir, for being with us. Thank you.
Sir. Thank you.
Thank you, sir. Now I would like to invite Anuradha ma'am. She is the coordinator of this course also, and CS arbitrator, IP and registered valuer, for sharing her insights on CIRP. Over
So,
to
thank you, Mr. Sohail. So basically, first of all, I would like to extend my thanks to Vanessa for taking this course so seriously and implementing it, giving it a practical shape. By virtue of this course, we are trying to align, like Sahu sir said, that IBC process is like an orchestra. So we are trying to make that orchestra by giving entire knowledge about IBC to all the participants, whether they are a valuer, they are lawyers, or they are from any other segment. Now coming to my part, the part that I will be teaching up, that is the CIRP process, that how the resolution plan will be the first stage of the IBC, because as you know that the CIRP is basically the heart and soul of the IBC. The intent is to give a second lease of life to the ailing corporate debtor. So how that plan is done, how the procedures are involved, basically the law part, because we have eminent faculties who are having expertise in their area, like Abhay sir or Mr. Harish or Narang sir. They will be giving insight about how the this process is done through the perspective of the different stakeholders that they will be giving up. My will be to give you an insight about the law that is related to the CIRP process, the code, the regulations, because first you should know the law, then you are in position to implement that law. So the knowledge of law is important. So that portion I'll be taking up in detail. I would like Sohail, I would request you to please ask other eminent faculties to give their insight, because I have already told what I'm going to take up, and we are having all those senior professionals with us who are going to give more insight on this process. Thank you.
Thank you. Thank you, Soyan. Thank you, Anuradha. And I would like to inform all that this course has been convened by Anuradha, and she she has really worked for months altogether on this creating this course, and with her help only, or with her vision, I think IOV has been able to produce such course, and for the benefit of all, which is the core issue, which is the core aim of our IOV, and with for this course per se. Thank you, Narada.
Thank you so much, Sir Vanessa, because without your help and your guidance, it could not be completed. So thank you so much for giving me all the infrastructure, all the support for creating this course. Thank you so much, sir.
Thank you.
Thank you, ma'am. Now, I would like to invite Mr. G.C. Narang. Sir is an insolvency professional and retired as a Deputy General Manager of Bank of India's largest corporate branch after a distinguished 40 years career. Sir, we would like to invite you to share your perspective on IBC for COC.
Yes, thank you, Ms. Gupta. As introduced, good afternoon, friends. I am G.C. Narang, an ex-banker and practicing insolvency professional. I am involved with insolvency profession from day one, from the day of inception itself. So I have practical experience on both the sides as a banker as well as an insolvency professional. Broadly, I have to brief you about the role of COC in IBC. By now, everyone must have understood that in India, the insolvency process is creditor-centric, unlike USA and certain other Western countries where it is debtor-centric. So creditors, how the COC comes into the picture and at what stage? After the application for initiation of CIRP, corporate insolvency resolution process as such, is filed either by the financial creditor or by operational creditor or by the corporate debtor itself. Once it is admitted, insolvency interim resolution professional is appointed who invites the claims, collates the claims, and thereafter forms committee of creditors COC. The COC as such, the composition of COC is all the financial creditors are a part of the financial creditors, may be bank or any financial institution like NBFC or asset reconstruction company. There may be AIF or other personal financial creditors as well. However, the composition COC as such is only financial creditors except for related parties. Related parties as such are not allowed to represent or vote in the meeting of COC. For meeting of COCs, all the besides the members of the COC, directors or partners of the company of the corporate debtor are also invited, though they have no voting right. Besides, operational creditors or their representative may also be invited, is also to be invited in case their admitted claims, I said their dues, are not less than or more than 10% of the total debt of the corporate debtor. But operational creditors as such also have no voting rights. They can only participate in the proceedings of the COC meetings. So COC committee of creditors, this way is the authority where all the main decisions of about the resolution of the company are taken. In COC composition, home buyers have also been categorized as financial creditors, and they are also part of the COC. And other class of creditors also, if they are class of creditors, then a authorized representative is appointed on their behalf. The role of credit COC starts right from the appointment of resolution professional to approval of resolution plan. In the first meeting itself, first meeting of COC, either the IRP who has been appointed by NCLT is continued, or it's at the discretion of COC members to appoint any other IP as resolution professional. And they have to appoint in the first meeting itself, which is then approved by NCLT. Then they have also the power to replace the RP appointed by them itself or by the NCLT. So right from that stage, appointment of RP to approval of resolution plan, they have the main role, COC as such. Major decisions, certain major decisions are to be approved by the COC. So RP as such had to conduct the CIRP. He had to manage the affairs of the company. He'll endeavor to do so by keeping it as a going concern. But for decisions, for certain approvals, he had to approach COC. So in my view, RP should be thorough with the provisions of the code as well as its rules, regulations, and certain other related laws as well. So I have to counsel the COC to take the decision to take the approvals which he has been putting from time to time. So in general, these are the major functions of COC. After approval of resolution plan, it goes to NCLT for approval. So while picking up the course, being an introductory session, I think broadly I have covered, and while taking up the session, we shall be dealing with the key provisions of CIRP, particularly related to COC. Then role clarity, RP, COC and other stakeholders, best practices to be followed, real life. I'll be supporting it by real life case law, my own experience as a banker as well as a RP. Then the mistakes we have to avoid, efficiency of strategy, and applying commercial wisdom with legal backing. In a catena of judgments, Supreme Court and other courts have also now been deciding about supremacy of commercial wisdom of COC in approving resolution plans, in approving so many other issues. And NCLT, while approving the resolution plan, had to only see that the compliances of the IBC as well as other laws are there. Otherwise, commercial wisdom of COC, since they have to see the viability, commercial viability and technical, everything they have to understand, evaluate the resolution plans based on the evaluation criteria, and take a call on resolution plans. So NCLT part is as per the various judgments of Supreme Court and NCLAT also, they have to see the compliance part. particularly section 30, subsection 2. So this is broadly, this will be in the session. I would be taking up also various case laws related to COC, CIRP. Thank you. Thank you, everyone.
Thank you, Narang sir. Being in as a banker and understanding the other side of COC, I would say it will give an edge for our knowledge purposes and for the benefit of the members who are going to participate in this program. They will be hugely benefited from your side and your experience as a banker and later on IBBI. Thank you very much, sir. Thank you very much.
Thank you, sir. Thank you for offering me this opportunity to share my views and share my experience with the participants.
Thank you, sir. Thank you.
Thank you so much, sir. Now I would like to invite Abhay Kumar, sir. He is an insolvency professional, registered valuer, and a business and software consultant. Sir has an extensive professional career of 3 decades with the government and corporates, and sir is also a senior faculty of our IOB and IOB RVF. Sir, we would like to hear from you role of IBC for the valuers.
Thank you, Sohal. Am I audible?
Yes, sir, you're audible.
Yeah. Okay. So good evening to all of you. This is a 10-minute session. So my objective of this session would be what I am going to cover during my detailed session. Those parts I'll be covering here with a brief introduction. So as we know, any economic unit may be a going concern or a gone concern. So insolvency start when it is going towards a gone concern. So from there, this insolvency and bankruptcy code kicks in and the whole process continues. As we know, valuation has a very major role in insolvency process. And rightly, when IBC was introduced in this country, valuers were not regulated. So initial valuation was from anyone who was either income tax valuer or associated with some of the valuation institutions. So they were doing the valuation. And I remember in the beginning, Dr. Sahu was very effective in bringing this profession to the limelight. And Mr. Vinay Goyal and Mr. Sahu, Dr. Sahu had a lot of interactions during the initial stages. And fortunately, I was also involved in certain stages when the whole thing was being formulated. And thanks to IBC, that valuation profession is now regulated and it is getting a market traction. We are slowly being recognized by the market as a true profession. So as we understand, valuation has a very major role in insolvency. And IBC itself is a evolving code. Since, I mean, if we see it, what was there in IBC code in 2016 and what is there today, I think each regulation, each act, by number of pages itself must have become double its size of this original volume. So that way, so many changes has happened, and a lot of changes has happened with respect to the valuation also. So initially, with respect to the valuation, there was a provision that value will be disclosed to the resolution applicant. Subsequently, that clause was done away. Now again, that clause indirectly has come up where value has to be disclosed in information memorandum with the consent of the COC. And if COC doesn't want to disclose it, then COC has to give a written reason for the same. So it has become very difficult for the COC to deny this important information to the resolution applicant. If we look at IBC, here the valuation provisions are at different places, right from the say CIRP regulations, then we have a liquidation, voluntary liquidation, personal insolvency, then pre-packaged insolvency, voluntary liquidation. So everywhere there is a provision for the valuation to happen, and that becomes a guideline for the for the resolution of the in any case. So, and the liquidation value is very important with respect to deciding if there is any descending creditor, then his stake in the overall CIRP process gets decided by the liquidation value. So that's why liquidation value is very important. Though in IBC, if we look at the process for the valuation is some kind of a summation method. Summation method here is that we have a 3 asset classes, land and building, plant and machinery, and financial asset. So each individual gives a value and then we add it up. So the drawback of this method is that we do not get the enterprise value of the organization. And one of the greatest example, live example for the same is when Bhushan Steel was resolved, the original valuation of the Bhushan Steel with respect to summation method was something around 18,000 crores. And it got resolved at the value of 36,000 crores. So that is what is the say difference which we are getting it as an enterprise value of a major steel plant with respect to the value arrived through a summation method. So there are certain things within the valuation aspect also which requires to be changed so that the real valuation should happen for an organization. Similar is the case with the intangible valuation also. Intangibility in majority of the cases never get accounted for in the IBC process. Then coming back to say what I'll be covering it during this course. So the entire gamut of say valuation exercise, starting from where it is applicable, how it is applicable, what should be the how should we carry out the valuation, how should we make our report, how should we as a valuer should not get penalized by IBVI or any regulatory authority that way. So all those aspects I would be covering during my detailed presentation. We now recent introduction is that in the IBC is that valuers have to present themselves before the COC to explain the methodology. I myself is part of many of the COC where I see that part is still not kicked off very in a very nice manner. It is like one of the ritual. So we have to come out from that ritual part to a real value part. And in the COC meeting itself, a valuer is getting the opportunity to interact with the COC. So he should form his view based on the COC interaction. And many of his queries may get addressed by the COC itself. So that is a good aspect which has been introduced in the IBC process. Then how we should use the background information what information we should put in the valuation report, what information we should definitely keep with us, so that if in future somebody questions us, then we should present them. And that is those informations have to be a very logical informations which convinces the stakeholder with the professional work done by the valuer. Similarly, all kinds of valuation approaches and all also I'll be covering it. What all documents should be enclosed along with the valuation reports. So right from A to Z aspects of the valuation, whatever I can cover it in 2 hour session, I will try to cover based on my past experience in running more than say 200 courses on valuation and regularly participating in continuous education program, be it with ICAI or IOVRVF or CMAI Institute. So thank you.
Thank you, Abhijit. Nice of you to be here, and I know the conditions you are attending this, but well, you are always there to share your knowledge and experience with others. You're the forerunner of our faculties. Thank you for joining us, and we expect more in the coming proper sessions of program. Thank you.
Thank you, sir. Thank you, sir.
Thank you. Thank you.
Thank you so much, sir. Next, we have senior partners from Luthra and Luthra Law Offices who are going to take our session on IBC for lawyers. We have Mr. Harish Kumar. Sir has advised Fortune 500 companies, government bodies, and industry associations. Sir has worked extensively with regulators such as RBI, SEBI, MCA, and CCI. We also have with us Mr. Gajanan. He is a senior advocate and a member of the Supreme Court Bar Association and the Delhi High Court Bar Association, actively contributing to the legal community through his diverse practice and professional engagements. Sir, we would like to hear your views on role of lawyers for IBC.
Hi, good evening, everyone. Am I audible?
Yes, sir.
Hi. First of all, my heartfelt gratitude to the entire set of the faculties who have been here to share their thought on this appropriate topic. Thank you, Ivy, for having organized this wonderful sort of workshop seminar, appropriately themed, which has been subcategorized for the relevant speaker. Thank you, Anuradha, for having structured this program, and thank you for having us on this sort of module to share a thought on the relevant topic, basically the role of lawyers throughout IBC. While we will be detailing basically the relevant aspect concerning legal process, procedure, do's, don't, modalities, so on and so forth, during the course of the detailed formal, module, which we are going to address in due course. I think 2 days were allotted to us, basically. In the meantime, we thought to share our perspective, on the IBC, how and what the lawyer should know. I think if you talk about the recent judgment of Supreme Courts, in the matter of Bhushan Power and Steel, wherein a resolution plan which was in place for the 5 years having put aside by the Supreme Court, to my mind, that speaks loud about the process of law. So if someone calls that this is something which would have shattered the kind of established principle of IBC, there is a threat to the potential acquisitions under IBC by investor, there is a threat to the COC. I may not be in agreement. Rather, I would say the Supreme Court verdict in this judgment has again put a stamp on the process of law. So what the apex court, which is the rule of law as on date, what they meant is that when there is a process of law, we expect everyone to sort of comply with the process. Interestingly, see, IBC is again a kind of acquisition of asset. We typically call it M&A. From Luther perspective, we have done sizable transactions from all perspectives, and we have represented different parties. We have represented COC in case of IBC mandate of sizable volume, something like that of recent acquisition of Hinduja by something like that of recent acquisitions by Hinduja of Reliance Capital, something like that of the acquisitions of SR Steel by Aslam Mittal. right? So we represented the investor, we represented the COC, we have worked extensively from and with the resolution, a professional. So one thing what I would like to share with you guys that when we talk about M&A acquisition or IBC, this is strictly distinctly different from a M&A transaction in normal course. For the simple reason that while in case of acquisitions M&A in normal course, we got a lot of flexibility, including the fact that both the parties, buyer and seller, have got free will sort of to come forward, discuss, negotiate, and structure the documentation. They are free to kind of decide about any timeline. They are free to decide about the commercial. They are free to decide about the detailed representation, warranty backed by the indemnities. We do not have the blessings of all those aspects under IBC for the simple reason it is an acquisitions of an asset, which asset is a distressed asset. So when we are acquiring, let's say we're representing a buyer, investor, or we are representing a seller, basically COC on behalf of the company corporate data, we have to mindful about the statutory constraint. And what are those constraints? These constraints are that this is a time-bound process. We have to complete the transactions in a time-bound manner. While I'm acting for my investor, while I'm acting for my potential incoming promoter for a company, I will be conducting the relevant diligence, but I don't have the flexibility to access the relevant information because not only the time is limited, but also the information supplied by resolution professional on behalf of committee of creditors is also may not be detailed. They may be relevant, but may not detailed. So I have to conduct my diligence accordingly. I have to ensure that the decision plan which I'm going to draft and submit, while it can be creative in nature, but I have to be mindful about the fact that the decision plan which I'm going to submit before the committee of creditors, which is ultimately going to put before the NCLT, has to comply with, has to have the mandatory contents as required in the IBC. And we have seen the fact that, order coming from the judgment coming from Supreme Court, which has recently put aside the Bhushan Power Steel's approved RP. They did mention that this plan, which was also not only lacking the contents, but also was not complied in spirit. Right. Also importantly, when I talk about a successful resolution plan, please be mindful about the fact, which is the core kind of objective of IBC, that maximization of the wealth of all stakeholders. Importantly, maximizations of the business of the corporate data. Importantly, we have to run the company as a going concern. So during the course of CIB process, post resolutions, we have to ensure that the company remains an ongoing and sort of going concern. There should not be a potential threat. Otherwise, there's a serious issue, from the court perspective. As a court, I'm not only talk about the NCLT and NCLT, but also the, kind of upper court, importantly, Supreme Court. One of the very important feature, which I always put it for the potential investor under IBC, is that whenever you're working on behalf of an investor, always go into and check whether or not the transaction, basically the potential acquirer, gets sort of, is subject to any kind of attribution under Section 29A. 29A, which talks about the eligibility or kind of disqualification. So we have to go to the relevant criteria, which is very subjective in nature. Importantly, if I'm acquiring an asset, right, and the asset is subject to kind of some potential threat from the perspective of preferential transactions, avoidance transactions, given the fact that the RP has a right to go into look back period of 2 years. In fact, in case of fraudulent transaction, there is no look back period of 2 months, though 2 years. They can even go prior to that. And if that asset got seized or there is some potential loss, then my entire acquisition may go in vain. So that's very, very important from the perspective of an M&A in the context of IBC. Interestingly, if I have submitted my plan and this has been approved by the committee, which has also been put before consideration, would have been approved or likely to be approved from NCLT, I should be mindful that unlike a normal M&A, I have no sort of, comfort, as to walk away from the transactions. These are provisions in law under IBC, specifically Section 74(3). They say that, any party that violates the conditions laid down, then the person is sort of likely to be prosecuted. And the prosecuted is not only in terms of monetary penalty, but also in terms of the imprisonment, which may go up to 5 years. There have been cases, by the way, I'm sure the learned members in the parliament would have known that, wherein the, the erstwhile, ongoing sort of resolutions of MTech Auto, Liberty House would have submitted, got approved, then they would have sort of taken aback, would have moved out while he would have been allowed to go, but there was a case filed against them before the NCLT, and the NCLT referred the matter to IBPI. So we have to mindful about the fact. But one of the very unique sort of aspect which I would like to put for everyone's considerations when we talk about an acquisitions, resolutions, restructuring, etc. under IBC, which is our distressed asset, is that see, it's a transaction where a lot of many parties have to work together to make it a successful. Unlike a normal M&A acquisition, buyer counsel will only solely talk about his investor, his party, and the seller counsel would talk about his party, seller, promoter, or the company. But this transaction, all the party, be it COC, be it resolution professional, who typically is a court-appointed official basis a recommendation by COC, resolution applicant, incoming investor, or the new promoter, we all have to work together to ensure that this transaction is a win-win transaction from all perspective, including the fact that it has to comply with the requirement of law. And this has become quite significant. As I said, I'm reiterating it post this Supreme Court verdict. So this is a sort of bird's eye view about how critical the role of lawyer would be. Certainly is going to be very critical. One of the relevant aspect, again, from the perspective of implementation of relevant provisions, if you talk about IBC brings a very sort of unique way of coming together different practice areas for a lawyer. So if you are typically a lawyer who does transaction in the context of banking or finance exclusively, I don't think you can undertake the transaction. You can advise the transaction. No. If you are a lawyer who is typically a litigation lawyer, I don't think you can advise on IBC as a whole. It's a team of advisor working together. Advisor means the lawyers coming from different practice area. Importantly, there are 4 practice area who have to work together: general corporate advisory, litigation, banking, finance, and the M&A and the restructuring. So these 4 streams you have to know in the process of throughout the process of advising to a client, be it COC, be it incoming investor, resolution applicant. That's how it's a kind of combination of different practice area. Not only that, as I said, when you're working from the relevant party, you have to also factor into the recommendation session by the opposite party. So what I'm going to do, I'm just taking a pause here. This is a as I said, a high level thought from how lawyer works under IBC. Now I'm requesting my colleague Gajanan, who will briefly take you through the kind of relevant do's on kind of high level thought surrounding the legal process, procedure which would be involved during the course of IBC. Again, I'm reiterating that we will be taking you through a sort of detailed thing during a 2 days workshop when we are going to discuss with you guys not only the process but also the practical things which we have to involve. Over to you, Gajana. You can take it forward, please.
Hi, good evening, everyone. Thank you for taking out time on a Saturday evening. It's difficult to be here on a Saturday and sitting in a webinar. And I'm grateful to Harish sir and IOB, of course. Harish sir has already, given everybody a bird's eye view as to how IBC works. Now, the important aspect which I would be dealing, because I'm a litigation lawyer, is he comes from a corporate background, so he's been advising clients, and he's rightly explained that it's a team of lawyers. So I'll be taking a cue from them, and a team of lawyers would consist from advising on a transaction of IBC, starting from the initiation of insolvency till the acquisition of a company by the resolution applicant. So before we start, as a lawyer, when somebody comes to you, and all of this will be explained in detail when we start taking the module. So we would start with how a company is becoming insolvent. So for that, you have to start with your due diligence of established debt. Then there is a default. How do you assess that? How do you see if there are any issues concerning that debt? Is that debt disputed? All of that, once sorted out, you can start planning your litigation accordingly. You have to bring the corporate debtor to the court, and that's when you have to consider the aspects of limitation, jurisdiction. Then you have to see what you're supposed to draft, and then you'll also have to see uh, which is the bank that is going to take up the matter. You have to accordingly prepare that you have to get the matter admitted, and then get the company admitted into insolvency. There will also be an important aspect of proposing a resolution professional who, key to so many resolutions. So, all of this has to be kept in perspective while, we start working towards, the insolvency resolution of a corporate debtor. So then comes the important aspect of handling a bench, different benches of NCLT. As professionals, we would have come across, deal differently with different issues. Like, in a Section 9 petition against an operational creditor, you would see a different approach that, if you can settle, why don't you settle? It is an operational debt, you can settle, why do you have to put the company into insolvency? Or why do you have to push it for a resolution when there are no assets? So all of these are to be considered. Then, there are aspects of financial creditors coming to the court. Let's say there is a consortium of banks. Then the lead banker would want to take the company to the insolvency because he's not able to recover. Few of the banks may disagree, they'll end up getting nothing. So all of these are the aspects to be considered. Then, there are approaches to handle the benches. Let's say a technical member would be in support of certain balance sheets, debt default, while a judicial member may not agree with you. These are the aspects you would consider while you would argue in a court of law and tell them that, this is the company which is required to be resolved under the IBC. And then there are aspects of, after admission, there comes the important aspect of a resolution professional who's appointed, how he is going to take over the company as a going concern. So for a company to be a going concern, a resolution professional, be it from any background, has to ensure, let's say it's a hospital, it's a company running a hospital, it has been admitted into insolvency. The resolution professional in 99% of the cases would not be a doctor or somebody who's seen administration of a hospital, but he would be required to take care of the all emergency services in the hospital, pay out to the doctors, inpatient management, pay out to the nurses, pay out to the sanitation workers and all of that. And he has to keep it as a going concern till the time there is a resolution arrived. So that's where a role of a lawyer would be crucial to advise him on an aspect of, how to keep it as a going concern, how the balance sheets are to be maintained, how the revenue has to be generated, how it has to be distributed while doing his due diligence for a resolution applicant to find somebody who's suitable enough to take over the hospital under the insolvency. So these are very crucial points for any lawyer to advise a client or a company. Then comes the important aspect of handling a committee of creditors. Everybody has spoken about it, in detail. You would be hearing from us also and other speakers also during the course module. But handling the COC and getting into a resolution mode is a very, very difficult task, even for a lawyer or a resolution professional. Getting COC to convince itself on a, with a 66% majority for any resolution plan, or for that matter, passing any resolution for any transaction, you have to sue for an avoidance transaction, you have to pass an information memorandum for the resolution applicants, you have to choose a resolution plan, you have to put the resolution plan for voting. Everything has to be guided by a set of lawyers. And the set of lawyers would have also need to have the commercial prudence. They need to understand the business of the company. They need to understand the approach of the COC, for a resolution to be effective and for any company to revive itself. It is quite important that the COC takes an informed call. And, there are set of judgments established now that the commercial wisdom of the COC has to be given primacy. So how do you ensure that? To ensure that the COC has decided correctly or has applied this commercial wisdom, a lawyer has to guide them, and that lawyer should have a background of a commercial approach and a background where he should be looking at the revival of the company, asset maximization, which is the aim of the IBC. All of these are the crucial aspects, and then there comes, sir has already highlighted the which all other speakers would also highlight, the recent judgment of Bhushan Steel, where you would see that a company is resolved in accordance with the provisions of the IBC if it is resolved. And if it is not resolved in accordance with the provisions of law, despite putting in money, it can be put into liquidation. And today it seems, this is the approach, legit approach of NCLT benches that, if a company is not complying with the timelines not complying with the relevant provisions which are required to be complied with, is being pushed into liquidation, which may not be an ideal solution, but that is also being done. Then once a company is put into liquidation, then also a role of a lawyer becomes crucial, because how a liquidation value has been arrived at with the help of the learned valuers who are also our audience. They would arrive at a liquidation value beforehand, and how that value has to be realized, how that value has to be given to the creditors, and how the company has to be resolved. That is a different process altogether, but lawyers are equally important in that, for you to decide, for creditors to decide, for the resolution professional who becomes a liquidator to decide how well he can distribute the realize the money from the assets and how well he can distribute. So all of this becomes crucial, and then of course the NCLTs would come into play when you have to file your relevant applications, how well you have to convince them to pass relevant order, how company has to be liquidated, how assets are to be distributed. These are the crucial aspects. Now, this is all IBC under the uh, NCLT regime. There are cases which are pending even before IBC came into being, are being tackled by the high courts. They also approach a different. They also adopt a different approach that in case a lawyer is called upon to advise, or any professional called upon to advise, they need to also be aware how high courts have been dealing with cases involving liquidation or winding up. So these are the key pointers which we had to share with you. And during our course of the module, we will of course get into the details of it, nitty-gritties of it. And this is only for the consumption at the initial stages. It will be a heavy course for you to consume on later days. Harish, tell me.
So while concluding, let us reiterate that to be a successful lawyer during the course of IBC, you have to have multi-skill rather than a specific area. You should more be acting as a business lawyer. More importantly, we have to make it a successful transaction deal under IBC. One, be it lawyer, be it valuer, be it COC, be it RP. My only advice, suggestion, and the learning is that to make it a impactful, successful transaction deal under IBC, one has to put his ego aside and hold the purpose in heart, and then work together. It's a transaction which requires invariably for people to come together, work together, achieve together. It's all, while you may have your sort of conflict, you may have your some sort of thought process, during the course of negotiation, discussing, but we have to work as a team to make it a sort of win-win sort of transaction deal at the IBC. With this, we take a pause, and I think again we would like to extend a heartfelt gratitude to Mr. Vinay Goelji, Anuradha, entire team of IV to have us, and grateful to the sort of galaxy of speakers on this panel. Look forward to working, contributing, and deliberating on conclusive manner. Thank you very much, sir.
Thank you. Thank you so much for
Thank
having me.
you, Harish ji and Gajanan ji from Luthras and Luthras, one of the most eminent and prominent, I would say, lawyers, attorneys of the country, and your vast experience in terms of IBC and the legal perspective, that is the most important. Ultimately everything goes to the adjudication process, so one has to be aware of the legal aspects and legal implications of whether one is a valuer or an IP or whatsoever. Ultimately it can go to the courts, and there the real test is, and that laboratory produces the real thing. And what you
Sir, in
said,
India, there is a saying about litigation. In India, only God can save you from litigation. And I made it. Actually, this is the way this system works. That's it.
I can tell my participants that people may think legal studies may be a little boring and all about acts and all. But with the presence of Mr. Harish Kumar, I can assure Ji, it is going to be interesting. And
We'll make sure, sir. I'll make sure.
and thank you for being with us and guiding us on creating this structure, the program as such. And we look forward to a very successful course ahead. Thank you.
Thank you, sir.
Thank you, Harish ji. Thank you, Gajanan
Thank
ji.
you, sir. Thank you very much.
Thank you.
Thank you so much, sir. Now I would like to invite the next speaker, Mr. Ankit Goel. He's a partner of founder partner of a AAA Insolvency Professionals LLP and a AAA Valuation Professionals LLP. Sir holds expertise in business valuation, insolvency law, debt restructuring, and taxation. Sir is a regular faculty of IOV and IOV-RVF. So we would like to hear from you the role of IBC for the support service providers.
Thank you, Sohailji. Once again, I think everyone is congratulating IOV, and I would also do the same. That is a very interesting and a very, very different concept for everyone to understand. This course, this certificate course in itself, I think is a very unique creation on IOV's part. On top of that, this today's session is also a very, very unique experience for me, where I have never seen that somebody is coming out with a certificate course and then also has a trailer for that course. So this is the trailer before the movie. And I think there's a very popular dialogue which says "Picture abhi baki hai." So I think the trailer is also a little bit left for me to finish. And I think I will take this opportunity. A lot of opportunities that are there from the IBC law, that come from the IBC law. We have heard from Dr. M.S. Sahu, we have heard from all these stalwarts in this industry. And I believe that I can share my piece or my experience as to what are the other professionals who can capture some opportunities from the IBC process per se. We have seen lawyers talk about it. We have seen valuers talk about the opportunities that they get. We've also seen, of course, within the IBC process, what opportunities are available. And I think I can talk about some other opportunities that we feel the need of when we start a process. One very important expertise, which is part of IBC, is the uh, buffet transactions. So buffet transactions are fraudulent transactions, or preferential, undervalued, or extortionate transactions, which are required to be dug out by the insolvency professional himself. Insolvency professionals almost always seek external help in seeking expertise, and they appoint experts to dig out those transactions for them. And that is a very, very comprehensive exercise, and it is also something which is very remunerative. Many chartered accountancy firms who are registered with IBA as forensic auditors and paneled with them get the opportunity of also doing transaction audits under this framework. So fraud detection is something that's a very, very important part of the entire process. Coming to the insolvency process, when we start the insolvency process as IPs, normal expectation is that we will complete or we will continue the going concern operations of the company. And there again, in complex industries, we see the requirement for process advisors or management consultants or industry specialists. So in case I am today an RP for a company which is involved in manufacturing iron and steel products, I might lack the expertise to verify and check the basic details with respect to how much material is being procured, how much material is procured at what cost, and how much manufacturing is happening there. So there again, there's an opportunity for those people who have experience in that sector to play a role. We then have the process where various compliances of any corporate entity are required to be completed during the insolvency process. So if the RP gets a listed entity, the RP is requiring a consultant or somebody who understands how to take care of the listing compliances. Similarly, we're talking about GST law, income tax law, company law, so many laws, labor laws. So one, compliance needs to be ensured. Secondly, in case there is any ongoing litigation which can be closed, which can allow for better value creation for the company, that is also something that is required there. We have a very, very important function within the insolvency and bankruptcy code, which is to prepare a resolution plan. And we understand that this is a very, very complex process where you have to have an understanding of law, you have to have an understanding of the business details, you have to understand insolvency law, and finally also you also have to understand that what is going to be approved by COC and what is going to be approved by NCLT. So that foresight and that acumen to prepare a robust resolution plan which passes the test of all the people who are going to go through that document is also very important. Then we have a lot of entities who support the IP through what is called Section 29A compliance. Section 29A basically says that for all the resolution applicants who come in, 29A says that one has to make sure that they are not related parties to the promoters of the company or the KMPs of the company. And that's where 29A compliance comes into picture. And for that, there are specialist organizations in the industry who do this compliance for the RP, give a report where they say that, yes, this is how they have checked that there is no relationship between the resolution applicant and the promoters of the company. We know that in individual insolvency matters, there are a lot of people who are now required to provide detective agency services for the purpose of understanding if there are any assets which are belonging to the individual people, which can come on the table, and for which the repayment plan can be considered. There are so many agencies that we have to hire for providing security services to safeguard the physical assets that we take possession of as an insolvency professional. We have to at times do asset tracing activities. So I remember doing an asset tracing activity for another RP, where we had to find out the ownership and the contractual rights that the company had for some animated videos for kids that they had made. So it's a very interesting thing. Sometimes you get where you kind of want to look for intangible assets and you want to trace them there. There's also a requirement for many RPs to take support services to take count of physical assets and inventory. They would require at times people who understand the maintenance and upkeep of machinery and would want their advice to take things forward. Completion of accounts is something for which many outsourced companies do the job for the RP. And we also see that the understanding technical documents and preparing for arbitration is also something that requires industry experts per se. So in case a company which is into tolling and a highway tolling comes to me as and I'm the RP there, I will have to perhaps appoint a professional or a specialist who understands how to take care of arbitration matters in case I have a dispute, which has the possibility of giving me or giving the company rather a lot of money through the arbitration process. We also see that a lot of people are into making on the other side with the resolution applicants or the resolution applicant advisors. So prospective resolution applicants would want you to advise on the legal process, would want you to advise on the valuation process. They would also want you to kind of make sure that yes, you understand everything about the company that you're wanting to purchase. So that's a very interesting thing. Today, anyone and everyone using this website called banknet.com can become a resolution applicant or a bidder for a liquidation asset. So that's a big thing. Many people have stopped doing their main business or automated their main business, and they're only adding value to their net worth through this inorganic expansion that they do. When we talk about support services, at the center of all the things is what we call as the support services from the insolvency professional entity. So like our IPE, there are many other IPEs, and all the IPEs have to have more than 50% of their ownership or their control in the hands of IPs. These IPEs support the IPs. The IPEs are appointed formally in the entire process, and these IPEs also need manpower to take care of various opportunities that come by, whether it is claim verification, whether it is preparing the documents, holding COC meetings, maintaining secretarial records, keeping minutes of the meeting, whether it is creating market for the assets, whether it is an asset sale team, whether it is those people in the organization who make sure that the security is in place. So many functions. The list goes on. I think I will share the complete list when we are having the session, but as many as 10, 15, 20 different specialists are required in an IPE to support an IP in carrying on the process. That's something that is very, very important. Uh, I think we also are always looking for mediators. We're also looking for people who would make sure that we are able to brief the bankers, the COC members, and the NCLT with respect to the merits of resolving a company rather than putting it into liquidation. So with that said, I think I will give it back to the IOV management, and I think that would have given a quick brief on what what I will be talking about during my session and how I will be taking care of all the remaining functions that are not being taken care of by lawyers, valuers, or other professionals.
Thank you, Ankit. But you're, as usual, you simplify the things with your experience, a lot of experience and knowledge, and being into this profession for now quite a long time. I think almost you formed the first entity with us, and
Oh,
the first entity of IBB, I would rather say.
yes.
Yours was the first entity as a registered valuer entity, and this participating and providing us all the inputs regarding this course is what you have already accomplished, and now we will look forward that all the participants in this course are benefited from your vast experience and intelligence you have. Thank you, Gil.
Thank you so much for those encouraging words.
Thank you so much, sir. Now I would like to ask the participants if they want to ask any question to any faculty. They can put it in a chat box and we can answer it accordingly. Or if anyone would like to speak, so they may raise their hand, please. We would also like to announce that the this course, first class of this course, is starting from going to start from 19th of July. The sessions are going to held on weekend, that is Saturday and Sunday. Saturday on evening timings and Sunday on the morning timings. The candidates who have registered themselves, they'll get all the details with the list of faculty schedule and the timings. If you are not
So
having any question, we may ask Anuradha ma'am to give the concluding remarks and summarize the session, please.
Thank you, Sohi, and thanks to all the faculties who have been here and they have given us significant inputs on the sessions that they are going to have in this particular course. A quick brief about the course for all the participants who want to join it. That we have divided this course in two parts broadly. One part is the mandatory one, where we are going to tell what the law is, and second part is about the implementation, which we have divided in different modules. Those modules are related to valuers, the bankers, the professionals, and the lawyers. However, I would personally recommend you should go for all the modules, because as a valuer, sometimes you will have to act as a lawyer, you have to think like a RP, and you have to take a decision regarding like a COC, right? Similarly, if you are a lawyer, you have to think that if you are going to challenge a valuation, how the valuer has done that valuation. So you need to know that also. If you are a COC, you need to understand that how the valuation has been done, what the mindset of RP is, how the lawyers are going to take this matter further, right? So this is my personal suggestion that in case you want to join it, you should go for all the modules, because all these modules are interconnected to each other. But in case of paucity of time or very specific situations, you go for individual module. That is also open with us, right? So once again, I thank on behalf of IOB RBF for sparing your time and coming to this webinar to have an overview about this course. And I would request you that in case you want to increase your career, you want to give a good graph to your career, particularly in the field of IBC, because just now Ankit has told that service providers include everything. You are a valuer, you are also required as a service provider. You are a lawyer, you are required as a service provider. You are an engineer, you are required as a service provider. Everything. All the professionals are there in the service provider category. So that is my personal recommendation, that you should go for all the modules. I'm most welcome to you all to join this course. We are there to help you, guide you about the modules. And in case you have any queries, you can mail it on the mail ID. So Hilji, if you can just give the mail ID on which the queries may be sent, so accordingly we can take it up further.
thank you, Anuradha ji.
Thank you so much, sir. And thank you, Sahu sir, Harish ji, Dhingra sir, Ankit, Anil ji, and Naran sir for sparing your time. Thank you so much, sir.
Thank you all, sir. Thank you all the participants as well, who have really borne total patience with us for almost 2 hours. Now it is
Right,
2 hours, not almost, but 2 hours. So
Yes.
thank you all. Thank you very much.
Thank
you
you,
so much.
everyone. Thank you.
Thank you. Bye-bye.
Thank you.
Thank you, faculties. Thank you, participants. We'll see you on 19th of July, who all have registered, and who all have not registered and have any kind of query, you can send it us at.
I think there is some question. There are some questions in the chat box. What are the deliverables and responsibilities that RV has possibly related to land and asset class? If Abhay can give an insight on this. Abhay, you are there?
Yeah, I'm there.
So if you can just see some question is there regarding the values, if you can just give an insight on that.
What are the deliverables and responsibility RV related to land and building? Yeah. So, I mean, from the deliverables per se, in one word, I can say the valuation report, which is delineated as per the IBC, means the three documents have to be referred there. One is your registered valuer rule, second is the IBC code, and third is the your valuation standard. So that should be your speaking document, and that should include all the enclosures what you need to put it in your valuation report.
Thank you so much, sir. So any other queries you want regarding the course contents, the fee structure, the duration, you can just mail up at the mail ID that has been given in the chat box, which is pro@iov.co.in. Thank you so much. Thank you.